Hi, this is Keith Davidson at Albertson Davidson. I want to talk to you about a very common problem that we come across all the time. So let's say you have a trust where the parents are now deceased. You have 4 siblings, 4 children that are supposed to share in this estate. They each have an equal share. And there's a house. So let's say there's one house or one piece of real property. And the trustee, who's one of your siblings, doesn't want to sell it. They want to keep the house. They want to rent it. They want to act as if they are going to continue to own it and control it indefinitely. And if your trust says that the distributions are supposed to be made to the children outright, the trustee cannot make the decision to just keep a house. That's not how this works. Outright distribution means that each of the beneficiaries must receive their share of the trust within a reasonable time. A reasonable time can vary depending on the estate, but it typically is anywhere between 4 to 12 months would be a reasonable time for you to receive your distribution. So if you want the house sold and the trustee says, no, I'm just going to keep it, I'm going to rent it, or the trustee says, I'm going to keep it and live in it, and you all, too bad for the rest of you, that's a no-go. The trustee cannot do that. Of course, they do it anyway, and that's where you have to go to probate court to stand up for your rights. And so what you would do is you'd file a petition in probate court, and you'd ask for a couple of things. One is you'd ask that the court order the trustee to list the property for sale. Secondly, you would ask probably for trustee removal, but you definitely want the house sold and you want the sales proceeds distributed out to you, hopefully directly from escrow. Now, if there's some other beneficiaries who don't want to sell the house, let's say there's 2 siblings that want to keep the house and 2 that don't want to keep the house. Well, the 2 that want to keep the house can buy out the other 2. That's certainly a possibility. But of course, everybody's going to have to come to an agreement about, well, what is the value of the house and what is the buyout percentage going to be. If you can agree on those amounts, hey, fine, then they can buy out the people who don't want to own the home. If you can't agree to a buyout amount, then the home's going to have to be sold. And ultimately, that's a good result for everybody because once it's sold, everybody gets their piece of the sales proceeds and they can go off and do whatever they want in their own lives, and you're not locked together anymore. So all too often, bad trustees will think that because they're trustee, they can just continue to do things the way they want to do them. They can continue owning things, they can rent it, they can live in the house, whatever. That's not the way this works. And the only way, unfortunately, to really get what you deserve in most of these cases is to file in probate court and ask the court to help you out. Albertson Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson Davidson, LLP.